Okay, welcome. Welcome. Yeah, I'm Uncle Tony. I'm from Trangie. We've got the Gowan Waterhole, one of our significant sites here, and unfortunately we couldn't be there today because it's raining here. So we're really happy about that. But welcome all. I'm on Whalan country. I'm Wongabon and Wawan ancestry. This is the Wiradjuri lands, and I'd like to welcome you all to my home. I'd like to acknowledge Aboriginal elders, past, present and emerging, and welcome any Aboriginal people into the conversation. The reason that I'm up front today is so that I can have a little chat to you about the wonderful things that we've been able to achieve here recently. So we've been trying for 40 years to get flows returned to the Trangie Cow and into the Gowan Waterhole. It's a very popular place here. It's a very significant place, especially for us, but for all the local people. And the flows were taken by big irrigation 40 years ago. We're trying to have those flows, or some of them, returned. We had a step forward, or step in the right direction. I was told last week that the Butter Lake and also the Gowan Waterhole will be now in the long-term watering plan. It's testament to the effort that's been put in by a lot of people. Mel, one of our main supporters, and we are hopeful now that we can start to see a significant increase in the health of our particular system. We've got a lot of work to do, and we still need a lot of help, but this is what we wanted in the first place. This is what we instigated, and we've had a lot of support from people in a lot of different places. I tell the story often, and I know some of you will have heard it before and probably sick of hearing it, but I've got to tell everyone we need as many people as we can on board with these things. We need to make sure that this floodplain harvesting legislation is monitored and corrected where necessary. We need the data that they use for these models, which no one seems to have or is not willing to give us. So all the things that we have been asking for, the fact that we can't get this information means that we are behind the eight ball. That's it in a nutshell. So the long-term watering plan for us means that the Gowan Waterhole and Butter Lake, and in fact the whole Trangie Cow, is like a mini marshes to us. It's a significant breeding area. There are freshwater fish, invertebrates. The native wildlife all go there for a drink. We want to see it healthy again, which it's not at the moment. We're working towards that end, and hopefully, in my lifetime, we might see some flows back in through that system. So that's about all I really wanted to tell you, to introduce you to where I live and what we do. Congratulations, of course, to the EDO and the Nature Conservation Council for this great work and this great outcome. And I won't preempt anything. I'll wait, like the rest of you, to hear the summary and the detail. Thanks very much, Mel.
Thanks very much, Uncle Tony. Yeah, we'll hand over to Jacqui for a chat from our CEO.
Thanks, Mel. And yeah, thanks, Uncle Tony. Thanks for being here, and great to hear a bit about where you're from. I thought we could just start by zooming out a bit and providing a bit of context on the case that we brought and how we got here. And thanks to everyone who's come along to hear a bit more about the case. I find water policy in this state and in this country, very complicated. It's a very complex area of management, and trying to understand the water sharing plans and how water is managed from a legal perspective, is very complex. So it's wonderful to have Emma Carmody here, and to have worked with the EDO on this case for the last few years has certainly been really good for us at NCC, and a learning curve. So if you've got questions, this webinar today is really about helping to answer some of those questions. But when we brought this case, we knew that climate change was already having an impact on the rivers and wetlands of New South Wales. They have had decades and decades of mismanagement and over extraction of water for irrigation, and compounded with climate change on top of that, the health of a lot of our river systems has been in serious decline. And we've seen a number of fish kills and species decline, and a really terrible downward trajectory in terms of the health of some of the rivers and also the communities that rely on those rivers for their lives and livelihood. And so it was clear that serious, bold action was necessary to really acknowledge the role that climate change was playing, but to turn around that trajectory of decline. So we launched this legal action with the EDO back in October 2021, alleging that the Water and Environment Ministers at the time did not consider climate change when they signed the Border Rivers Water Sharing Plan. So under the Water Management Act, the water sharing plans have to be signed off by both the Water Minister, but also the Environment Minister has to sign off on it as well. So the case was brought against both the ministers. And at the time we brought the case, we had a coalition government in New South Wales, and then following the election in March 2023, the current Labor government inherited this court case. So it did give us quite a bit of leverage, I think, in terms of getting a good settlement out of court when it came, when it came time to negotiate with Labor ministers. And one thing that is tricky in the water space is how you get leverage on an issue that does have, it's hard to get political traction, I suppose, when there are very few voters thinking about water, and the populations that live out along the water, out along our inland rivers, there's quite a small number of voters really. So trying to think strategically about how you can get leverage on an issue that's not necessarily a vote winner for the government. And water management in New South Wales has been very much stuck in the past, ignoring climate change, rolling over extraction limits based on figures from the past, ignoring the needs of the environment, using flow data that's very much outdated, and not considering recent droughts. So just I think a week or two out from the case scheduled, from when the case was scheduled to be heard in the Land and Environment Court, we sat down with the government bureaucrats and their lawyers, representatives of the ministers, to negotiate and to come to an agreement on settling the case out of court. And so we got new and significantly improved programs of work for the Water Department. That means that the needs of the river and the projected impacts of climate change are factored in when limits to extraction and water allocations are made. So, we're really, while it's been a really long process from when the case was first brought to now, and, a lot of up and down around the merits of going to court or settling out of court, where the place that we got to in terms of the settlement is really good news for how climate is factored into water management in New South Wales. So we were really pleased with that outcome. But in terms of a bit more detail on what that actually means and what that looks like, we can hand it over to, I think we're going to hear from Richard now, Mel, and then Emma. Is that the case?
How did I have it? Let's hear from Emma first.
Right.
This is Emma Carmody. Emma was the managing lawyer with the EDO of the freshwater team when the case was brought.
Good morning, everybody. I'm coming to you from the lands of the Gadigal people of the Eora Nation here in Sydney, and I'd like to pay my respects to all elders past, present and emerging. And thank you to Uncle Tony for your welcome, and to Jacqui as well for providing that context, which was extremely useful. I've been asked to briefly discuss some of the background to the case and why it was considered important to commence these proceedings. In order to do that, it's necessary to go back in time a little bit and talk briefly about the genesis of the Federal Water Act and the Murray-Darling Basin Plan, and work that was done at that time and since around the impacts of climate change on water across the basin. I'm sure most of you are broadly familiar with the fact that the first decade of this century was at the time the worst drought that we'd ever experienced since the beginning of recorded history, since colonisation. And during the course of that drought, it became eminently clear that leaving water management to the states, when the basin is an interconnected system of 23 different catchments, was clearly not working, that over-extraction was being compounded by climate change, and it was necessary that the federal government intervene. And so that's exactly what they did under John Howard in 2007. Malcolm Turnbull was then the Water Minister. They legislated the Water Act 2007. It's a long and complicated piece of legislation, but really its primary focus is to reinstate what's known as an environmentally sustainable level of take, which, as the name suggests, is a level of extraction from our rivers and groundwater sources that is consistent with the ongoing health of those rivers and water-dependent ecosystems and species. And the chief instrument through which that ESLT, that environmentally sustainable level of take, was to be implemented was through the Basin Plan and then other pieces of delegated legislation known as water resource plans. A lot of scientific work between the MDBA and the CSIRO was undertaken in that first decade to try and work out what an environmentally sustainable level of take would look like. And in around 2010, they published what was called the Guide to the Basin Plan. And according to that scientific document, between 4,000 and roughly 7,000 gigalitres of water needed to be returned to our rivers and wetlands and aquifers in order to ensure we met this requirement of an environmentally sustainable level of take. And they included in that some consideration of climate change, a 3% buffer. So they worked out what they thought an environmentally sustainable level of take would be based on the historic climate record, which was 114 years of collected data up until 2009, and then they added 3%. Fast forward to when the Basin Plan was actually legislated in November 2012, and as you're all probably very familiar, in the end, not only did they not include a reduction figure that took into account climate change, it also wasn't sustainable based on the historic climate record. And so the Basin Plan legislated for 2,750 gigalitres of water to be returned to our rivers and wetlands and aquifers. Since that time, that figure's been further amended and eroded. Many of us working in this space considered what could be done about what we really consider to be an existential threat to the health of the basin and its water-dependent ecosystems and communities. And though consideration was given to potentially challenging the Basin Plan, we also did think about what we could do under state water laws, because we do have legislation in each of the basin states, starting with the Water Management Act in New South Wales, which brings us to our case. The Water Management Act includes in it a number of water management principles and an associated duty. And one of those water management principles is essentially that water sharing in New South Wales has to ensure that water and water-dependent ecosystems are protected. And then there's a duty that's incumbent on all people exercising functions under the Act to ensure that they act in accordance with that and other principles. So that was the beginning of our legal analysis to determine whether a water sharing plan could be challenged on the basis that it didn't properly abide by those obligations in the Water Management Act. and also wasn't consistent with some of the objectives of the Water Management Act. And it was in light of that we had a look at the Border Rivers Water Management Plan when it was remade back in 2021. We put together a brief and we sought advice from Brett Walker, and the end result was that we were advised that we did have a case. Now, that doesn't mean you'll necessarily win the case, but what was advised was that we had reasonable prospects. It was a sensible case, what we were proposing to run with the NCC. And so we commenced those proceedings and then sought leave to put on expert evidence, and we won that. And I know Richard's going to speak as well. And the expert evidence was really very briefly just to explain what some of those impacts have and will be if we continue to fail to take into account climate change in our water management and the impact of that on water-dependent ecosystems in the border rivers and in interconnected systems. So that was really, broadly speaking, the basis of the case. Your job as a public interest environmental lawyer is to test the limits of existing legislation, to be reasonable in doing it, and we were being reasonable in doing it, which is why we commenced proceedings on the advice of our barristers. But that was really why we were doing it, that there was this trajectory of mismanagement. We'd considered other options. There was a growing body of evidence going back to the creation of the basin plan, and in fact predating that, which showed what the likely impacts of climate change would be across the basin. And we decided that it was necessary to intervene with litigation, which is something that, I mean, I have to say personally, I don't take lightly. You really only do it as a last resort. So I think I'll leave it there and hand over to the next person.
Thanks very much, Emma. Our next person is Professor Richard Kingsford. I recorded a chat with Professor last week. He's on his way, weather permitting, out to a gorgeous inland place. Of course, he's busy buzzing around all parts of the country. So we'll play this video. If you know how these things go on Zoom, it might crackle and, it might not be smooth. So maybe it might help to turn your camera off. That might improve the bandwidth. But let's see how we go. I'll share my screen. So just give me a sec while I do that. Okay. Hear from Professor Richard Kingsford.
Thanks very much, Mel. It's obviously really important to talk about the health of our rivers and the big changes that have happened, and also think hard about what the effects of climate change are going to be on both the rivers, their flooding, and also the many plants and animals that depend on them, and obviously all the people that depend so much on our rivers.
Yeah, absolutely. So you were going to give evidence at the NCC's water and climate change case, which was settled before it went to court. What were the main points you wanted to get across if you'd gone to court?
I guess, the focus of the court case was on the border rivers up there at the top end of the Murray-Darling, and we're talking about the McIntyre, Dumeric, and Severn rivers that flow across the border of New South Wales and Queensland. And I guess I've worked in that part of the world quite a bit. We've done surveys over more than 40 years on the wetlands of the border rivers. And there have been major changes in that system. So, the big dam, Pindari Dam, there was a big increases in its size, which regulated that system. And then we've seen a lot of development on the floodplain there in terms of cotton irrigation, but changes to the flooding patterns in that system. And we've been tracking waterbird diversity and abundance across numbers of waterbirds and the different species over time, now 40 years of data. We haven't recently looked at that, but the long-term indications are declining numbers in that system. And I guess, this is the sort of major background of what's happened to the border rivers. Then when you're looking towards effects of climate change, which are happening now and projected to be increasingly challenging in the future, particularly around climate change, and how does that register in terms of river flows, and what we do know is that temperatures are increasing, and that means that there are challenges in terms of evaporation of water in these systems. We're not so sure about what's happening to the rainfall, but it's certainly increasing in its variability. There's certainly been some work that's in the public arena done by CSIRO that's indicating that on medium climate change scenarios of around 2030, that water availability is going to decrease by 10% in the river, and runoff even up to 24% across the Murray-Darling Basin. So, the problem with that is that maybe, and again by CSIRO works indicating that 10 to 20% reduction in stream flows by 2060 is a severe impact that we've got to manage for, because essentially that's the water that our native fish depend on. The plants along that river, we know there are coolabah, red gums, black box all along the border rivers floodplain. But more broadly, this is an issue that's relevant across all of the rivers in Australia, and particularly the stressed ones in the Murray-Darling, where we know that there have been significant impacts of building dams and diverting water. So it's really problematic if we're not managing for water supply. The whole planning process is really about what's the available water, and if we don't adequately incorporate climate change into future management, that just really makes a nonsense of our ability to plan. Planning is about the future, and we're not doing that.
Settling the court case, are you confident in how we could do it better in the future?
Look, I think it's challenging, and I don't think nobody would disagree. I mean, there's not an endless supply of water, and we know that whatever you do in water management, it's going to have an effect somewhere on the amount of water that's there or available to users. Again, some of the pivotal work done by the CSIRO indicates that the water that's held in dams is less impacted than what we call the planned environmental water, the water that goes down the river and keeps it alive. And that's a problem, because the whole idea behind the basin plan was in respect to climate change and changes in availability, then the costs or benefits, for that matter, if there was more water in the system, would be shared equally. And so governments and communities have this challenge about how do they get some equity in the way we share the pain, because it seems to be pain. We're going to get less water in the rivers. And currently the management settings don't seem to allow that to happen. So general security, high security, including flows available by the Commonwealth Environmental Water Holder and the New South Wales Government, and obviously irrigation in towns, is going to be less affected than the water that we need to run the rivers. So what then, the solutions then become difficult. If you want to make sure that you've got enough water to run the rivers, then you're going to have to find that from somewhere. And the only place you can find that from is your water supply in the dam. And so I think the details of how that will be brought into operation is something that we all need to discuss as a community. I don't think it's certainly not an issue that's only relevant to the New South Wales rivers. It's relevant to Queensland, parts of the basin. It's relevant to Victoria, South Australia, and in fact, the whole nation. So this is a conversation and policy and management that we need to develop together, knowing that there is no easy answers. And if we are really going to ensure that we've got as healthy rivers as possible, we need to really grasp this nettle. Otherwise, we're not actually going to deal with the problem.
And how important is it that the plants and the animals and the whole connected system is healthy? Why can't we just send a bit of water down a channel?
Look, I mean, the river is only as healthy as all of its bits are. And we know that all of the rivers in the Murray-Darling are not just the main channel. They've got floodplains, they've got what we call distributaries. So these are channels that come off the main parts of the rivers, and they're all meant to run water. And they're meant to run water when the river gets high enough to get out onto the floodplain. And unfortunately, with river regulation and diversions, we're getting less and less of that. And with climate change, that'll be shallow water in a very hot climate. A lot may evaporate before, the things like native fish need to get out onto those floodplains to breed. We know the water birds are the same and the frogs, but it's really the whole ecosystem that depends on that flow and flooding. We're talking here about the River Red Gums, the country there that's needs to be healthy to deliver not only for the aquatic plants and animals, the things that we don't really care about, like the microscopic invertebrates that are really the bottom of the food chain, and the plants there. But increasingly, we're understanding that these ribbons of green through our dry continent are really important for a whole range of different species, including things like woodland birds that need to come into these areas during the dry time. So this is not just a simple question of saying we just need to run a bit of water down the main channel. We actually need to keep the whole of that river and its floodplains as healthy as possible.
Thanks very much, Professor.
Thanks very much, Mel.
I hope that was okay of watching experience. Yeah, good. Thanks. Fantastic. Okay, so now I thought I'd spend a few minutes explaining the settlement, and then if you have any questions, just pop them in the chat and we'll have a little Q&A after a quick explanation of how we went. So as Jacqui mentioned, this case was raised in 2021, and just days from when it was due to be heard in the Land and Environment Court, NCC managed to secure some commitments from the current Environment and Water Ministers that made us comfortable to settle the case before it went to that long and complicated court process. So where we are now with water management across the state is that extraction limits are based on how much water has been taken in the past. And these limits just tend to get rolled over and rolled over every 10 years when the water sharing plan is supposedly remade and reinstated. Instead of a good shake-up of the system and a good assessment of what we need moving forward, what's tended to happen since the mid-90s is that, well, since then, but then when water sharing plans came in, that these limits just get rolled over and rolled over. Sort of the status quo just keeps carrying on. These limits have never been worked out from what the river and the wetlands can actually afford to give. When water allocations are made, which is a different process that happens throughout the water year, they are made using a fixed set of data from basically last century. That means that recent droughts, and we've had some severe droughts in the current century, those recent droughts have to be ignored, which means the settings are are set on hyper, if you like. So the dams drain really, really quickly, regardless of the climatic outlook. That's a change that was made in 2015 by the former water minister, one of the former water ministers in the former government. And a lot of work has been done on what the projected impacts of climate change are. So there was a process done after the shocking 2017 to 2019 drought. Regional water strategies were done for every catchment around the state. And in those reports and for that process, a whole heap of really solid science was done and independently reviewed by the chief scientist, New South Wales chief scientist, and published in regional water strategies. And if you want to have a look at your region, then I think Sam will pop the link into, there where the regional water strategies, the ones I know, particularly the one for the Macquarie, the Wamble is quite scary, to be honest. The projected impact of reduced flows on our system. So it's really solid science. But this solid science wasn't considered when the actual rules that share water were made. So that was the point that we were pushing with the case. So the commitment that we have secured from the current government guarantees a review of the extraction limits for water sources across the state, not just the border rivers. This review is to be completed by 2027 and 2028. This review of extraction limits is to take into consideration what is required to protect the water source itself and the ecosystems and the wildlife that rely on that water source, and really critically, the health of connected water sources. So what's happening downstream has to be considered when limits upstream are made. This review also has to consider the climate change projections as per the science in the regional water strategies that I mentioned. There will also need to be consideration of the cultural, social, and economic values in that catchment. And yes, you might be thinking that's a little bit of a red flag there, but there will have to be a discussion in the community, like Professor Kingsford mentioned. Everybody needs to get involved with such a big change to how water limits are set. So we really need to take, you know, really close look at what we value as a community. That'll all have to come into play. Currently, outside of this settlement, there's a review of what we call flow targets in unregulated water sources that are in inland New South Wales. So there's work being done by a panel called the Connectivity Expert Panel. This draft report should be out later this month, I understand, and a final report by mid-year. So we're very keenly looking for this draft report. Flow targets in unregulated systems as a way of managing irrigation extraction would mean that you know, you have to wait for the river to get to a certain height for a certain amount of time at a certain place before extraction is allowed. So the community are really looking forward to the outcome of that process, and we accept that the work done by the Connectivity Expert Panel is a really important precursor to reviewing extraction limits in those unregulated systems as well. So this work that's going to be going on, reviewing these extraction limits, is time to align with the evaluation of the basin plan, which is happening in 2025, and the review of the basin plan in 2026. Incorporating climate change into the extraction limits at basin plan level for the whole basin, for all of the states, Queensland, New South Wales, ACT, Victoria and South Australia, that incorporating climate change into those limits, as well as the delivery of cultural water to basin traditional owners, are two very key objectives of basin plan number 2, which is to commence from 2027. So we think the timing of this commitment is absolutely critical as well. And the work that we intend to do here in New South Wales can really push along the work that needs to happen in the other states as well. The Natural Resource Commission will be asked to review the work of these reviews before the methods are adopted, and these reviews are also to be independently assessed. So that's the extraction limits. The second part of the agreement is around the way water is allocated. So already existing, the department are reviewing the way that water allocations are made for 7 regulated inland water sources. So a regulated water source is a stretch of the river with a big public dam in it, and water, when water users order water, that water is released from a dam. So that's different to an unregulated system where water is managed through different mechanisms, but it's not released from a dam. There's no dam attached to those, immediately attached to those unreg water sources. I hope that was clear. It can get very confusing and muddled water talk. So in those 7 major inland regulated water sources, the existing review of the way water allocated is going to be now expanded to consider not only the full record of inflows, like consider the most recent scary droughts, but also to consider climate change projections looking forward. The review will also cover some additional inland regulated water sources and coastal regulated water sources. So it's been spread to all over the state, not just the basin, as a result of our court case settlement. The results of these reviews will be made publicly available, and the Office of the New South Wales Chief Scientist and Engineer will independently review what they call the minimum inflow review. So that's a summary, a high-level summary on the details of the settlement. So we'll go to some questions and answers. If you've got any questions, just chuck them in the chat or maybe even raise your hand. And we'll have a look at Claire. Claire's question, growing cotton is insane in Australia. Seems like it is. Well, Claire, I guess it doesn't really matter what the crop is. It's the rules that allow the volume of water to be taken, and the conditions, the rules and the conditions of that take. So like in dry times, it's really important to protect water for the river, more so than in less dry times. So growing cotton per se, well, it really doesn't matter what the crop is. If those limits are so high, then that water is going to be extracted, and you know, they're going to grow something with that water. So, you know, it happens to be cotton that is really taken off in the Northern Basin. There are the tributary rivers of the Darling Barker. It's really taken off since about, well, it's really gone off since about the 90s. But that's the way of our markets. And yeah, so I guess it doesn't really matter what the crop is. Those water limits we are saying are too high. Yeah. Any comment on all those water impoundments made by farmers? I do have some comments about all those massive water impoundments made by farmers constructing huge levees in cotton areas. So what we're talking about here are floodplain harvesting levees. So floodplain harvesting is a way of just running levees across floodplains and diverting water from its natural course of filling floodplains, filling wetlands, recharging aquifers, and returning to the river in most cases, diverting that water into private dams. That practice has really exploded in the last, since the 90s. It's really grown a lot, and recently, just at the end of the term of the last government, that has been licensed. So I think the way forward with floodplain harvesting is looking at that really important work that the Connectivity Expert Panel are doing around flow targets in unregulated systems. So that's going to be a really important place to start. Because the environmental requirements of downstream were never assessed, were never worked out and considered when all that floodplain harvesting water was licensed. So that is the way to bring floodplain harvesting within ecological limits, is to look at those flow targets, and that work is going on, which is good. So Winston asked about land clearing. I'll invite Jacqui and Emma too as well, and Uncle Tony, to answer any of the questions in the chat as well, or any additional comments from the settlement itself. Winston asked about land clearing, especially of native forests and pine plantation considered a water management issue. I think most certainly more to the coast, that's the case. I don't know, Jacqui, if you out here in the Central West, and Uncle Tony can attest to this, we've been cleared for quite a while.
Yeah, I think I mean, obviously that creates huge issues with runoff and yeah, problems for how we manage our water systems. But yeah, don't have a broad understanding of the implications of land clearing on water management?
Certainly, we see an impact on water quality when upper catchments are degraded and there's excessive stock. Impact on riparian zones, especially in upper catchments, and the loss of so many wetlands because of change in flow, flow behaviour has really meant that those really critical riparian zones, that vegetation along the side of the river and in wetlands, that cleans so much of the water. So that's, in terms of land clearing, definitely that bit along the actual river banks is really, really critical.
Did you want me to add something, Mel?
Please.
On that issue, just I guess a legal perspective, the way environmental laws have evolved has meant that unfortunately we tend to address different aspects of the environment in separate pieces of legislation, which obviously is inconsistent with the fact that the environment functions in a far more holistic and integrated manner. So in terms of your question, we largely deal with water management and native vegetation entirely separately under different pieces of legislation. Perhaps one of the few exceptions to that is with respect to some of the approvals under the Water Management Act in New South Wales. So Mel just referred to riparian vegetation. If you are undertaking land clearing within 40 metres of a watercourse, then you will need, unless an exemption applies, you will need a specific approval under the Water Management Act for that purpose. But generally speaking, land clearing and water, despite the fact they are inextricably linked from a broader environmental perspective, legally they are generally dealt with quite separately.
Thanks very much, Emma. Justine asks, will the Minister's draft legislation to incorporate climate change, update the drought record, flow targets, etc. in all water sharing plans after their review and prior to 2027? Carving that up a bit, the review on extraction limits that consider climate change and all of the other elements that we mentioned before, that the undertaking is that the extraction limits, so I'm just looking for the exact words the ministers have said, but at a high level, that work, which is expected to take 4 years, the intention of the ministers is that review be ready for the water sharing plans to be updated for Basin Plan 2. So with new water resource plans, and I say that unironically, given that we still don't have all our water resource plans accredited in New South Wales, which of course has been a big issue especially under the former government. So it's very critical. There are so many steps to take before in the next 3 or 4 years. So what these commitments have done is provided a whole heap of things that must be, a whole heap of precursors. And of course, on top of that list is getting those water resource plans accredited. We still don't have all of them in yet. So that's the timeline with the extraction limit work. With the drought of record, the commitment that we have is that that there will be changes to the regulated water sharing plans by 2027. 2026, finalised by 2026. So they will be considered, that's when the review will be done, but the outcome of those reviews, that will be considered when water sharing plans are remade, by my interpretation of that. But what we have got is a case where, you know, we can all, as a community, really get involved in this process and ensure that it happens as quickly and effectively as possible. So really following every process is what I'm saying. Yeah, get these things done as soon as we possibly can.
Can I just add something, Mel, which I think, broadly speaking, I'll attempt to respond to some of the questions that have been raised. I've worked in water and water law for a very long time across most jurisdictions in Australia, so for almost 20 years, and a lot of that work has been in the basin. It is, I think it's fair to say, one of the most politically fraught areas to work in as an environmental lawyer or an environmental advocate. And because of the complexity and the politics of it, there is never and never will be a single silver bullet that will ultimately resolve all of the concerns that we collectively have about the sustainable and equitable management. And by equitable, I'm also referring to Indigenous rights, Indigenous water rights. There is no silver bullet. That is my experience over 20 years of working in the space. It's something that we have to collectively keep fighting for. And cases like these, settlements, future cases, other advocacy work, they're all part of continuing to push for incremental change. And what tends to happen is you will get these windows of opportunity where it will culminate in something significant happening. And so I think that the point for me of the settlement is that it represents yet another incremental change that's pushing things in a particular direction that we think is important for the current and future health of the basin. And I'd encourage people to continue advocating around the terms of the settlement, because now you've got something really concrete to use as a point of accountability with the current government.
Yeah, beautifully said. Thanks, Emma. That's exactly right. We think that this settlement, these commitments are a great place to start for what we consider our work plan for the next 3 years, to really do everything that we can proactively to get these commitments into the law. So in a lot of ways, this is just the start for us. But it's a lot more than we've had, you know, in the past, of course. So we are really excited to be able to be proactive. Quite often we've been reactive and, you know, limited capacity and doing what we can. But this settlement allows us to really plan the next 3 years and work really cooperatively with the ministers and the community, you know, yeah, see if we can and get some of these really important commitments turned into law. So yes, we feel like we're at the end of something, but the beginning of something even bigger, as always. Yeah, there's a question here about is 2026, 27 fast enough? I think that it is going to take a long time, and like Emma said, absolutely water improvements in water management are incremental, but I think there are things that the state government can do very quickly to secure water supply ahead of potentially the next drought when it comes. Things like introducing a drought reserve in the public dams. At the moment, they're allowed to empty them right down. And we saw that in 2019. We had, 1% in our dams. We were facing we were facing 90 communities in regional New South Wales on the list for evacuation. And we had, wildlife death all over inland New South Wales and the coast. It was a really horrific time, of course, with the fires as well. There was nothing to stop those dams from emptying, no setting, no rule to get. So we're saying once the dams get down to 4 years worth of critical town water supply and basic river function, let's stop with the other releases and just look after the actual basic river and the people for a couple of years and give the drought a chance to break. There's a question here for you, Emma, and I'm just looking at the time. We've got 1 minute left. I'm just looking at your question, Kate. Can you see that, Emma? Have you got
I saw it, Kate. It's a really good question. Just very, very quickly, there's an agreement between New South Wales and Queensland with respect to water sharing in the border rivers, because the border rivers catchment straddles both of those states. And Kate has quite pertinently asked whether it would be important to review that agreement. And I think that there is some utility in reviewing that as well. Absolutely.
Yeah. That's on our list of things to watch. Well, thank you, everyone. I haven't gotten to everybody's questions, but we are out of time. So stay in touch through our socials and our emails and things. And thank you for your interest. And I'd like to thank Sam for helping out. Thank you, Jacqui, Uncle Tony, and Emma. Thank you very much, and Richard for recording. I hope you all have a great day.
Thank you, Mel. Thanks, everyone.